sure my ringer is up. That would be good.
Good afternoon and welcome to the Center for American Studies annual Constitution Day debate. I cannot tell you how thrilled I am to see all of you. Do you know this is the first voluntary in-person event since this whole COVID has begun? So this is really exciting for us. And part of that excitement has to do with our speakers. I'm going to introduce them in a moment. I'd like you to take a second and turn off or silence your phones, and please stay off them during the event. Thank you very much. Secondly, let me introduce myself. I'm Elizabeth Coffer-Bush. I am co-director of the Center for American Studies here at Christopher Newport. Our center is dedicated to teaching America's founding principles in history, economic foundations, and national security policies. Every year, we host a Constitution debate to celebrate our history of free speech and civic discourse in the country. This year is the 15th anniversary of the Center for American Studies, so we have a capital campaign going to raise $200,000 in student scholarships, yes, for you all, as well as we're working on endowed professorships. So stay tuned to hear about our alums, hear about what our students are doing, and some special events that are starting in September. What is Constitution Day? Well, it commemorates the signing of the US Constitution in 1787 on September 17th. If you do math quickly, that means you know it's the 234th anniversary. This is also called Citizenship Day, a day to celebrate those born or naturalized as citizens, which brings us to the topic of debate this year. What does the Constitution have to say about immigration? And I could not be more excited to introduce our two debaters today. We call it the Battle of the Two Ilyas. These two esteemed gentlemen are equally well-statured, as well as often confused. You're a little taller, okay, all right, academically statured. And they have some similarities in their past that make this debate especially interesting. They're both immigrants to this country, both from Russia, both have similar cultural heritage. So I learned that they, as well as being confused with one another, happen to have very different opinions on immigration. I thought they could share those with us today. So let me introduce them and then I'll tell you the format and then I will hand it over. Professor Ilya Shapiro is Vice President of the Cato Institute, Director of the Robert A. Levy Center for Constitutional Studies and publisher of the Cato Supreme Court Review. Before joining Cato, he was Special Assistant to the multinational force in Iraq on rule of law issues and practiced at the Batten Boggs and Cleary and Gottlieb. Shapiro is the author of Supreme Disorder, Judicial Nominations and the Politics of America's Highest Court, co-author of Religious Liberties for Corporations, Hobby Lobby, the Affordable Care Act, and Constitution. You can also already see they don't shy away from controversial topics. And also editor of 11 volumes of the aforementioned Cato Supreme Court Review. He has contributed to a variety of academic, popular, and professional publications, Wall Street Journal, Harvard Journal of Law and Public Policy, Washington Post. I could go on and on. But I don't want to take up their time. He also regularly provides commentary for a number of media outlets such as CBS News and others. Ilya Somin is Professor of Law at George Mason University. His research focuses on constitutional law, property law, democratic theory, federalism, and migration rights. You may have heard of his recent book, Free to Move, Foot Voting, Migration, and Political Freedom, and it's currently being updated as well. Democracy and Political Ignorance, Why Smaller Government is Smarter, and among others. I'm only highlighting a few. His work similarly has appeared in numerous scholarly journals, Yale Law Journal, Stanford Law Journal, Northwest University Law Review, and others. He's published in popular press as well, Washington Post, Wall Street Journal, and others, and also USA Today. And the list is unending for these two fine gentlemen. So we're going to flip a coin. I need someone to call the coin, though. Okay, what's it going to be?
We're going to call it in the air.
Heads?
Well, I'll call it in the air when it's in the air.
Oh, okay.
Heads.
It is heads.
All right.
All right.
I'll receive.
You'll go second.
No, I'll go first.
You'll go first. Okay.
I was making a football joke.
So this is Ilya Shapiro. Will be going first. The format is that he'll have 15 to 20 minutes, and then Ilya Somin will respond in 15 to 20 minutes, and they each get 5-ish minutes. And then we have open question and answer. So without further ado, please welcome our guests.
Thanks very much. It's great to be with you. Thanks for having me. It was a nice drive down. Your campus is beautiful, and I'm delighted to be again. This isn't the first time on a panel on a debate discussion with my friend Ilya Somin. And you know, we don't disagree that much on immigration policy. Most of our disagreements are on the law, both constitutional, statutory, and otherwise. And I think we'll tease that out. But we're also very different personally. You know, Professor Bush said that, you know, we have similar background and whatnot, but that couldn't be farther from the truth, you see, because I was born in Moscow and Ilya Somin was born in St. Petersburg. So this is worlds apart, right? You know, he's the poet. I'm a hard-headed analyst of the law and of power politics. So I'm just going to tell you how it is, even if you don't like it, even if I don't like it, because this is one area which I love discussing, immigration law and policy, because it's a place where my policy preferences and my legal analysis diverge. And you should be, you know, you should ask your professors to identify, especially if you're talking to law professors, identify an area of constitutional law or public policy where they think something is a good policy but unconstitutional, or, you know, lawful but bad policy, because that really shows whether there's any integrity to the analysis, or it's just kind of filling in your legal theory to match your particular preferences. But you know, I'm sort of autodidactic on this topic. I've never taken a class in immigration law. I've never practiced immigration law, but I am one of the few people you'll ever meet who's naturalized twice. So I was born in Russia. We came over to Canada, took a wrong turn at the St. Lawrence Seaway, and I grew up in Central Ontario and naturalized there, and then came down to the US for college and law school. And now, like most immigrants, I do a job that most native-born Americans won't, and that's defending the Constitution. So again, I'm not an immigration policy expert or even an immigration lawyer, just a simple constitutional lawyer with the lived experience of an immigrant. Now, very briefly, this is where I think Ilya Somin will go more into, and where one of our points of disagreement is, and that's where there is a federal power over immigration regulation under the Constitution. There's a naturalization clause, but that speaks of naturalization, how you become a citizen. There's the the foreign commerce clause, but immigration isn't really commerce. There's the foreign affairs clause, which deals with, you know, foreign relations with other countries. Somewhat different, doesn't fit. There are historical cases that have justified various immigration regulations under all of these constitutional provisions, but it's just not right. I think it's more honest to find it in the plenary power doctrine, sort of as an incident of sovereignty. Every country gets to control its borders, regulate who gets to come in, that sort of thing. It's as implicit or not as judicial review, right? Marbury versus Madison confirmed that the Supreme Court gets to evaluate the constitutionality of acts of Congress. Well, similarly, it's sort of implied that a government gets to regulate flows of control its border flows of people, that sort of thing. You know, Ilya Somin is going to say there's no explicit immigration regulation clause, which is true. And indeed, at the founding and after, basically, it was very hard to get to this country. You had to cross an ocean. I mean, nobody went through the Mexican desert. There weren't that many people there anyway. But if you got to the country, you could be there, but, you know, nobody was going to give you anything. You know, had to make your way, and as long as you weren't a criminal and things like that. Or eventually, in Ellis Island days, you were checked for public health, which makes sense. I mean, I'll get into this. A sensible immigration policy would, you know, the only restrictions would really be for you know, public health or criminal background, terrorism, that sort of thing. And that's why the naturalization clause was so important, because there was a distinction between foreigners who were here and those who were becoming American. But in modern day, of course, this is why it's hard to analogize a separate debate over birthright citizenship, why it's kind of hard to analogize because there was no conception when the 14th Amendment was passed under which birthright citizenship is constitutionalized of someone who is here illegally. Well, what does that mean? You either got here or you're not. You're either a citizen or you're not. I mean, that's a distinction, but in terms of being here illegally, that wasn't a thing, but it became a thing, just as control of international trade, which has its own clause, but here it's, as I said, plenary power doctrine. It's not a neat prescription. It's not, but just like we have, in addition to judicial review, eminent domain, the power that the government has, federal or state, to condemn certain property for the public interest, for the public use. That's nowhere stated in the Constitution, but it's a background because we see the takings clause that provides individual rights protections against that. I think it's a similar sort of form there. In any case, everybody knows that our immigration system is a mess, possibly the most screwed up part of the federal government, which is quite a statement, believe me, particularly coming from someone from Cato. But it's true. Far from just advancing bad policy, our current system lacks a coherent policy in the first place, because our system is a remnant of various half-baked reforms going back decades, a schizophrenic set of laws that don't advance any particular goal. If you tried to create procedures for how foreigners enter the country, how long they can stay, what they can do here, it would be hard to come up with something less efficient or effective than our current hodgepodge of often contradictory regulations. This immigration non-policy has led to a state of affairs that serves nobody's interest. Not the rich or the poor, not big business or small, not the most or least educated, not the economy or national security, certainly not the average taxpayer, except maybe lawyers, bureaucrats, and the private prison industry. I guess they benefit from what we have. And yet most people agree on the problems that we face from this dysfunction. So first of all, there are 10 or 12 million illegal aliens living in the law's shadow. And that always reminds me of the great Canadian-American actor John Candy's last movie, Canadian Bacon, where he played a paranoid sheriff in Buffalo that was afraid about the invasion from the north, convinced the White House to go on this public service ad campaign with the tagline, "Canadians, they walk among us," right? People living in the shadow, which isn't good for them. It's not good for the rule of law. Then we have an issue with scientists, engineers, researchers, businessmen with no path to a green card or citizenship or even a work visa. So we educate and then we send them back to India, China, Russia, or they go somewhere else, Canada, Europe, Australia, Chile. Have you heard of Silicon Valley? The tech sector in that country, it's basically a wholly byproduct of the American immigration system. There's also an issue with employers who are unable to find legal and reliable manual laborers despite high rates of unemployment. As Alabama and Georgia found when they put in about a decade ago various state-level restrictions, crops rotted in the fields and things like that. Then we have border states and counties that face a disproportionate burden relating to the provision of social services and law enforcement. So it's not like, immigrants, legal or illegal, are all in one place or spread out evenly throughout the country. Certain places have greater benefits, greater burdens, that sort of thing. And then we have, of late, issues with asylum claims, particularly with families and children, and how do you deal with those? But Congress, for various political reasons that cut across party lines, has been unable to fix anything, regardless of the party in power and whether the president spent his own political capital to push immigration reform like Bush did or not, like Obama did not in his first term and then just decided to act alone through executive action. Nothing's been done. And then Trump's aggressive attempts to change the system accomplished little more than outrage civil rights groups and spark a flurry of legal challenges. Biden's signals going the other way then contributed to a crisis at the border. People thought, oh, now it's going to be easy and we'll just flood the border. None of this has actually addressed the underlying problems plaguing our immigration system, which have to be fixed by Congress, by the federal legislature. I'm a big federalist. I believe lots of things should be handled, most things should be handled at the state and local level. But immigration is one of those things that there's room for state flexibility in terms of state-based green cards or work visas, what have you. We can get into that. But in terms of, it's a country that has to control its own borders. We can't have Utah and Arizona, each having different rules about who can come in from where and which border. Although I would say that if Arizonans really cared about socialists who are lazy coming in, maybe they should build a wall on their western border rather than their southern one. But anyway, even before Trump, state governments feeling tremendous pressure to address the consequences of the federal failure to meet the nation's immigration needs acted for themselves. Again, about a decade ago, more now. Arizona was the tip of the spear, but we saw various immigration-related laws passed in states as different as Utah, Georgia, California, Texas, and whether related to enforcement, work permits, sanctuary cities, or other types of policy innovations, Congress and the executive's abdication of their duty to manage our immigration system has spawned a host of federalism experiments that don't work too well because they can only nibble around the edges, trying to add new criminal restrictions, for example, because immigration is, with a few exceptions, a federal responsibility. And now, as far as the law is concerned, a lot of things that both states and the federal government have done are unfortunately legal. SB 1070 itself, Arizona's big immigration restrictions. For all the brouhaha at the time, most of SB 1070 went into effect. The federal government only challenged 6 provisions, 4 of which the lower courts enjoined, and 3 of which the Supreme Court affirmed in 2012. The most controversial provision, the show me your papers, that police have the power to check the immigration status, or are required to, of anyone who they've lawfully detained whom they suspect is in the country illegally. The Supreme Court approved that unanimously, at least facially, as long as there wasn't racial discrimination, that sort of thing. And that's because the federal government's theory there was that because enforcement priorities had changed, states calling into the immigration hotline were burdening federal agents. Well, that's kind of an argument for preemption, meaning federal law trumping, federal policy priorities trumping state law on the whim of the president or the Secretary of Homeland Security or whomever. State law can suddenly be unpreempted, then preempted again. That's not good constitutional law. That's not the way the Supremacy Clause works. If the federal law directly clashes with state law, federal law trumps. But if it's just a policy priority, then that's not how that works. Which isn't to say that Arizona's law was smart. In fact, we saw that Arizona was harmed economically. Workers moved out of their state. The housing market collapsed. Lots of other problems that are attributed to that law and a related one, law. How much time do I have left? Is there a timekeeper? Are you going to hold up like 5 or 3? Sorry? 3 minutes? 8 minutes. Okay. Could you hold up like 2 or 3 at some point? All right. Thank you. I'm not going to focus so much on policy. Often when I do these debates, it's kind of the reverse. I'll be with like a restrictionist with whom I might agree more on the law but disagree on the policy, in which case I have lots of economic statistics and crime statistics. For example, immigrants, whether legal or illegal, are a net economic benefit. It's not even close. Crime rates are much lower for immigrants, including illegal immigrants. Anyway, this is not really disputed. Assimilation, unfortunately, immigrants do assimilate fairly well. Our assimilation engine might not be as quick as some other times, but to the extent that we have problems, it's because there are certain pathologies within American society itself. And so the communities that immigrants can assimilate into might have problems, but it's not that they become un-American or don't, by the 3rd generation. Political attitudes really aren't differentiated, for example, let alone language ability, from the communities in which they reside. But anyway, that doesn't mean that we can accomplish any reforms at the drop of a hat or by waving a magic executive wand. President Obama said 22 times that he couldn't just legalize people, the dreamers or otherwise. The dreamers are kids that were brought to this country illegally and have never known another country effectively. But nevertheless, that's what he did in November 2014 first in June 2012 with Daca, which legalized the dreamers, and then in 2014 with DAPA, Deferred Action for Parents of American Citizens and Permanent Residents, which has problems of administrative law, statutory interpretation, constitutional power. That is, there are provisions that temporarily allow the suspension of removal, deferred action is what it's called, of people who are in the country illegally. But you can't just create a new temporary status that's then renewable kind of as a bridge to somewhere, but Congress hasn't acted. So the bridge kind of falls because there's nothing for it to lean against on the other side. Unlike other times where deferred action has been exercised, for example, students displaced by Hurricane Katrina who are then out of status, or in the wake of humanitarian crises in Central America or Haiti or elsewhere that President Clinton was reacting to. Anyway, we have these temporary measures that are put in place. Eventually, either the emergency goes away or Congress regularizes, creates new statuses, and so that's all right. But that's not what President Obama was doing. He was creating new status out of whole cloth without any connection to future legislative action. And that's why I think it was lamentable. I wrote in the Washington Post how I would love to have the DREAM Act, or the legalization of the Dreamers, or more broad reform, but Obama poisoned the well on legislative action and actually was counterproductive to the whole project for reforming our immigration system. And Cato filed briefs. On the cover, it said, Cato, a couple other people, and other supporters of DACA against, or of DAPA for that matter, against the legality of those particular executive actions. Eventually, the Supreme Court affirmed an injunction against DAPA 4-4. That's after Scalia died, so the court left the lower court ruling in place. Trump then rescinded DAPA. He tried to rescind DACA, but Chief Justice Roberts rewrote the law, as is his wont, and basically said that he didn't jump through enough hoops. We kind of have a ratcheting effect, apparently. Every president has more and more power, and the subsequent president can't rescind that. During his first week in office, President Trump signed several executive orders relating to immigration, even before the rescinding DACA Supreme Court case. And this included ordering the construction of a big, beautiful border wall with Mexico, withholding federal funds from so-called sanctuary cities, temporarily banning entry for nationals of 7, later 6 majority Muslim countries, and indefinitely suspending the entry of all Syrian refugees. These orders met with immediate opposition, both legally and politically. They clearly were not lawyered up very well. You had Stephen Miller giving the legal advice rather than actual lawyers. That's not the way to run a lemonade stand, let's just put it that way. Eventually, the third travel ban was upheld by the Supreme Court. This is another point of disagreement that I have with Ilya Somin, because the way the jurisprudence works, the Supreme Court is not going to second guess the executive on national security determinations, nor is it going to make base constitutional arguments on random stray tweets, when we know that things that Trump said or tweeted aren't necessarily what eventually gets lawyered up once he allows the lawyers to do their jobs. Sanctuary cities orders, this is largely where Ilya and I agree that the federal government can't, after the fact, force states to enforce immigration laws if they don't want to. If that wasn't part of the contract they agreed to get their law enforcement funding or something like that, it has a whole host of problems, whether commandeering state officials that the federal government can't do, or adding new conditions, new strings onto federal funding. Anyway, lots of legal issues going on there. Ilya and I disagree more on sanctuary states. So California put in various regulations that arguably interfered with federal enforcement by restricting private actors and inspecting federal, not state facilities. That case eventually ended. California got most of what it wanted. I would have gone the other way on at least 2 of 3 of those provisions. Mentioned Daca rescission. I think the court, if it was going to do what it was going to do, that Trump didn't jump through enough hoops, then I think Justice Thomas in dissent was right to say that at that point the court had to evaluate whether what President Obama did was constitutional in the first place, because otherwise the court's saying, yes, we'll allow this potentially unconstitutional action just because you didn't cross the T's or dot the I's or issue the right memos. And as with respect to the big, beautiful wall, well, Trump's ability to do that without congressional appropriation is pretty limited. There are other issues with eminent domain and environmental regulation. And even if the reappropriation of certain funds from military construction or other things towards a wall is appropriate under the statutory text, which is questionable, then there's a whole issue of non-delegation. That is, Congress is effectively giving the president the appropriation power, which it's not supposed to. Supreme Court hasn't enforced the non-delegation doctrine in 80 years, but nevertheless, that's how I read the Constitution. And now Joe Biden is entangled with, DACA was again enjoined by a lower court, so we're litigating that again. His Remain in Mexico policy, court said he has to put that back in place. Again, these competing back and forth executive orders is not a good way to run an immigration system. Fundamentally, the problem we face is that Congress hasn't had an immigration reform, hasn't passed one in 25 years. It hasn't reckoned with the idea that there's no line to get into for people to apply to. I first immigrated, my parents, we came to Canada. We were refugees, but they also had a point system that if you spoke the language or had useful skills, you were more likely to get in. Other countries do it in other ways. We don't do any of that. It's largely family-based, but then it's largely kind of gamesmanship based on what kind of lawyers you have, how you work the system, et cetera, et cetera. And amnesty is kind of a misnomer. It's, any kind of immigration reform is always sullied as being an attempted amnesty. There no serious reforms contemplate forgiving anyone who's committed any crimes. Instead, we're talking about hardworking people chasing the American dream. They're not becoming welfare queens. They're not even eligible for welfare until they become green card holders and not eligible. The people don't generally come here to become citizens. The only difference between being a permanent resident and a citizen is the right to vote. You're forever beholden to the IRS and serving on juries. I'm pretty sure nobody naturalizes for those reasons. That's part of the reason why it's been difficult to legislate reforms is because the Democratic Party only will settle for a pathway to citizenship, even though most people who come here don't care about that. They just want to live here and work and be free to lead their lives and what have you. But of course, if you're not a citizen, you can't vote. And so there's that poison pill on that side. The Republican Party, even though they agree with the Dreamers, generally agree with legalizing, those who were brought here as kids, don't want to give that away because that's their ace in the hole for leverage over other things. And so you have this complicated game theory where no reform
And that's about time. So
okay, let me conclude by saying that sorry, I didn't see any time, but let me conclude by saying what we need to do is to liberalize the system and then crack down on those who ignore it. So if you screw up or go too long without a job, you lose your visa. But everyone gets a chance, and we should have lots of different kinds of flexible visas, not just kind of the rigid employment-sponsored things now with naturalization. Thank you.
I'd like to start out by thanking Christopher Newport University for organizing this event and all of you for coming, and the other Ilya for his thoughtful contribution to this debate. As you'll see, there's actually more agreement here on some issues than meets the eye, though there is some significant disagreement over several key points. At the very least, if you learn nothing else from this debate, you will learn how to tell the two of us apart, which in many situations is a serious problem. There's even an Ilya confusion hashtag on Twitter that chronicles all the instances where Ilya confusion has come up. A couple years ago, I wrote a blog post called Ilya Confusion, a guide for the perplexed, which tries to explain how to tell us apart. And hopefully after today, at least, you won't have that problem. I'm going to focus in my presentation primarily on three big picture issues. One, is there even a federal power to restrict immigration in the Constitution? And it won't be surprising to say that the answer is no, it's nowhere listed. Secondly, let's say that there is such a power. At the very least, I'm going to suggest it should be limited by all the same constitutional constraints that restrict every other federal power, like the Bill of Rights, for example. When the federal government regulates commerce or spends money or does anything else, they're constrained by the Bill of Rights. They're constrained by other constitutional provisions that protect other kinds of individual rights. Nothing about immigration should be an exception to that, even though sadly, under current Supreme Court precedent, it is. Finally, I'll talk very briefly about federalism and sanctuary cities, because I think we actually largely agree on that. And while most of the argument that I'm going to present to you is based on the text and original meaning of the Constitution, at the end, I will say something about how non-originalist considerations play into this debate. Not everybody is a constitutional originalist. If you're not, you also have some reasons to agree with me on these key issues of contention. So first things first, the title of this debate is, what does the Constitution say about immigration? And the answer to that is actually very simple: almost nothing. And the very fact that it says almost nothing is an indication that this power is not actually granted to the federal government. It's not like the founding fathers only enumerated a few of the most important powers and left all the details for later extrapolation. There's a long list of different powers given to Congress, including such minor things as establishing post roads, creating a system of weights and measures, and on and on and on. Yet there's no listing of a power to immigrate or to restrict immigration. That's not because they didn't think immigration would be an issue. To the contrary, many of the founding fathers expected there would be extensive immigration, and there already was in the 70s, 80s, and 90s. George Washington, in his orders to the Continental Army at the very end of the Revolutionary War, he said America was going to be an asylum for the poor and oppressed from all over the world. James Madison, Thomas Jefferson, other founders said similar things. So it's not that they didn't think there would be a lot of immigration, it's that they didn't grant the power to restrict it to the federal government. There are nonetheless people who claim that there are other powers listed in the Constitution that can be seen as including a power to restrict immigration. Ilya Shapiro mentioned some of them. The most obvious might be the naturalization power, but as he also mentioned, and I agree, and the founding fathers also agreed, all this does is enables Congress to grant citizenship to people who are not already citizens, but that's not the same thing as keeping out immigrants. And if you look at debates in the founding era, including over the very first Naturalization Act in 1790, they well understood this distinction. Similarly, one could argue that the power to regulate foreign commerce is a power to restrict immigration. Some people have argued that, but in the founding era and for decades thereafter, it was understood that the power to restrict commerce is a power to restrict trade in goods and services, to limit imports and exports and the like. And people, at least free people intending to migrate, are not goods and services. If you want to say that they are, then the very same clause of the Constitution also gives Congress the power to regulate commerce among the several states. So by implication, that same power would give Congress the authority to prevent Americans from moving from one state to another. And nobody at the founding thought that. Even today, nobody would argue that it has that authority. So you can't fit it into the commerce power. Some people would also say, well, maybe it can go into the necessary and proper clause, because there's this clause of the Constitution which says that Congress can enact any laws that are necessary and proper for carrying into execution other powers granted to the federal government. The Supreme Court has interpreted necessary in a very broad way as anything that's useful or convenient. I don't really agree with that, but I'm not going to try to debate it here. On the other hand, the court has said this as far back as Chief Justice Marshall in 1819. They've said that proper means a power that's not a great and independent power. So you can use the necessary and proper clause to tack on some minor additional power that's necessary to implement some other authority that's already listed in the Constitution, but you can't use it to tack on a great and independent power. I think it's pretty obvious that the power to restrict immigration is not just some small minor thing. It is in fact a great and independent power. I'm not the first person by any means to suggest that there isn't a general federal power to restrict immigration. People like James Madison, the father of the Constitution, Thomas Jefferson, and other leading founders said very similar things way back during the founding era when they had the debate in 1798 over the Alien and Sedition Act. Today, people mostly remember this for the sedition part, where you can't criticize the president and other violations of freedom of speech were enacted. But the alien part was just as significant at the time, and that included an act which said that the president would have the power to expel any aliens he shall judge dangerous to the peace and safety of the United States. This led to an upsurge of protest, including by James Madison and Thomas Jefferson and others. Madison said the Alien Act exercises a power nowhere delegated to the federal government. And Jefferson and Madison and other critics of the act prevailed. For the next 70 years or so, there were almost no federally imposed immigration restrictions. It was generally agreed that such a thing would be unconstitutional. Now, some people argue, as Ilya Shapiro does, that yes, nowhere is there listed a power to restrict immigration, but it's got to be in there somewhere, because all sovereign nations have a power to restrict immigration. We just would infer that that power exists. This runs into the problem that the founding fathers did list quite a lot of other powers in the Constitution that every sovereign nation is supposed to have: the power to tax, the power to declare war, the power to raise armies, and on and on and on. So there's not some clause or assumption that they didn't need to list things that every sovereign nation is supposed to have. Moreover, in discussing this very issue of immigration restriction, James Madison warned against this very argument in his report of 1800, when he said that we should not assume that the federal government in the US has any powers that European governments are traditionally assumed to have. The whole point of the founding of the United States was not just to imitate whatever powers European governments had. If all we want to do was that, there would have been no need for the American Revolution to begin with. Rather, it was to limit government powers in various ways, including eliminating certain powers that European despots took for granted. And this was one of them, as James Madison pointed out. Nonetheless, when the Supreme Court finally recognized 100 years after the founding in 1889, when they finally held that there is a federal power to restrict immigration, this is the theory they used, the theory that this is an inherent power, what I like to call the it's got to be in there somewhere theory. Like, we can't actually find it in the text, but we have to find it somewhere. And there's just no proof that it actually has to be there. Moreover, I would add that when they upheld the Chinese Exclusion Act, which, as the name implies, was an act excluding Chinese immigrants of most types, that act was heavily motivated by racism. And it wasn't just the act that was motivated by it, it was the Supreme Court's decision. And when I say that the decision was racist, I don't mean that it was racist in some broad definition of racism that you might get from critical race theory or some other modern academic idea. I mean that right there in the text of the opinion, they say that one of the reasons why the Chinese immigrants have to be kept out is because of the, quote, difference of race. Their words, not mine. So not only is this precedent founded on terrible legal reasoning, but it's also heavily influenced by racism. That doesn't by itself prove that the decision is wrong. Decisions with bad motivations might still be correct, but it does mean we should not give it a whole lot of respect based merely on the fact that it's a longstanding precedent. At the very least, courts should be willing to erode it, to apply it in a more limited way, and I hope eventually to overrule it. This decision came just 7 years before Plessy versus Ferguson, which most of you have probably heard of. It was actuated by many of the same racist motives. It was brought to us by almost exactly the same set of justices, and it deserves about the same level of respect. One was heavily influenced by racism against African Americans, the other by racism against Chinese. Therefore, I don't think this inherent power theory that you see in the Chinese exclusion theory is a good theory, and it's certainly not a very compelling precedent. Nonetheless, I do acknowledge it's unlikely the Supreme Court will overturn this in the near future, or perhaps even at any time. All we can hope for is that they will at least limit that decision in various ways and gradually push back on it. But even if they don't do that, they should at least recognize that if there is a federal power to restrict immigration, it should be subject to all the same constitutional constraints as any other federal power. There's nothing in the Constitution which says immigration restrictions are exempt from the Bill of Rights or exempt from other individual rights protected by the Constitution. There are a few constitutional rights where it does specifically say this is a right of citizens of the United States, like the Privileges or Immunities Clause. There are one or two which say this is the right of the people. There's a debate about who exactly the people are and whether the people are limited to citizens. But most constitutional rights actually are are drafted as generalized limitations on government power, like the First Amendment, for example, many other provisions. And they are not structured in such a way that there's anything there which says that it's limited to American citizens. Yet the Supreme Court, again, dating back to the late 19th century in the era of the Chinese exclusion cases, has ruled that to a large extent, the immigration restrictions are actually exempt from normal constitutional constraints on government power. You see this most recently in the Trump travel ban case, which Ilya Shapiro mentioned, where Donald Trump had repeatedly said that the point of this travel ban is to target Muslims. He said it many, many times. And by the way, he said it with respect to all three versions of the travel ban, not just the first and the second. If something similar had happened in a domestic sphere, it would have been struck down if there was strong evidence that the real motive for the enactment of a law or a regulation was actually to discriminate against a particular religious group, would clearly have been struck down. And in fact, in the same month that the Supreme Court decided the travel ban case, they decided the Masterpiece Cake Shop case, which involved religious discrimination by the state of Colorado. There, the evidence of bigoted motivation was actually considerably weaker than in the travel ban case. Only 2 out of the 7 decision makers involved had made bigoted statements, whereas in the travel ban case, there was 1 decision maker who was crucial, the president, and he had umpteen times revealed his motives to us. Yet the court struck down the policy in the Masterpiece Cake Shop case, but upheld in the travel ban case. Why? Because they said immigration policy, the president gets special deference. There's no such immigration exception in the text or the original meaning of the Constitution. There's not even an exception for non-citizens or people being dealt with outside US borders. And in the founding era, they recognized that. For example, in the founding era, they recognized that pirates captured at sea, even if they were not US citizens, they were still protected by the Bill of Rights provisions that they had to be given a fair trial before they could be punished and the like. If this applies to foreign citizen pirates captured at sea, it certainly applies to peaceful migrants attempting to enter the United States. And like the Chinese exclusion case, this aspect of the plenary power doctrine, this sort of exception for immigration policy when it comes to constitutional rights, it dates back to the Jim Crow era. It was heavily actuated by racist motives. Most immigration laws of that period, and actually many later periods as well, had heavy racial and ethnic motivations, either in discrimination against Asian immigrants or later against Southern and Eastern Europeans, people like Ilya Shapiro and myself. Therefore, the court created this doctrine for many of the same reasons that they created Plessy versus Ferguson during the same period. It is sometimes said that maybe there are other sort of unenumerated powers that Congress or the president has, or the other branch of government have. I actually think there's none anywhere near as great as immigration. Ilya Shapiro mentioned the power of judicial review, but that actually is specifically listed in the Constitution. Article 3 of the Constitution gives the courts the power to decide cases and controversies arising under the laws and Constitution of the United States. You can't decide these cases or controversies without being able to rule whether a particular law is unconstitutional or not. If it's challenged, there's the power of eminent domain. I actually think, A, that's a less important power than the power to restrict immigration. And B, I'm actually skeptical of the Supreme Court's decision in the 1870s saying that the federal government had the power of eminent domain. I highly doubt that decision was correct. We can talk about that later in the debate if people are interested. Lastly, I'd like to talk a little bit briefly about federalism and immigration. Under the original meaning, would the federal government have only very limited power over immigration and certainly no general authority to keep immigrants out? States had much more power, and states did enact their own immigration restrictions during that period. I disapprove of most of those restrictions, but they certainly were constitutional at the time. And if we restored the original meaning today, they would also be constitutional, though the states would not be allowed to impose restrictions based on considerations like race, religion, and others. And I would add that There's a long list of other constitutional rights which get violated in the immigration system because of this exception. For example, in our system of immigration detention and deportation, we repeatedly have situations where the procedural protections are so weak that thousands of people who are actually US citizens get detained, and in some cases deported because the authorities don't bother to figure out whether they're US citizens or not. We also have situations where you have absurdities like toddlers representing themselves, quote unquote, in deportation proceedings, because unlike in other situations where there's a serious deprivation of liberty threatened by the government, there is no right to counsel in immigration proceedings, or at least the government is not required to provide you with counsel if you can't afford your own. Very few toddlers can afford to hire their own counsel, so they end up representing themselves. You don't have to be a constitutional law scholar to recognize that that's wrong and unconstitutional. Finally, I'd like to briefly talk about, let's say you're not an originalist, maybe what are some things that might influence you in this debate. there are a number, but I would focus on just one in the limited time that I have. And that is, if you look at the trend in constitutional law over the last 100 years, it's towards greater protection against discrimination on the basis of things like race, ethnicity, and sex. Why have courts moved in that direction, and society in general as well? It's because we have come to recognize that race, ethnicity, and in most cases, gender as well, are morally irrelevant characteristics that people have no control over. So whether you're white or black or Hispanic, whether you're male or female, it doesn't say anything about what kind of a person you are. It doesn't, it's not something you can control, and it certainly shouldn't dictate how much freedom and opportunity you're allowed to have. Well, all of our immigration system works on similar principles. It restricts people based on who their parents are or where they were born, which are just as morally arbitrary as whether your parents were black or white. Martin Luther King said that we should judge people not by the color of their skin, but by the content of their character, because the color of your skin, your race of birth, is something that you cannot control, and it doesn't dictate what kind of person you are. Place of birth is much the same way. Whether you're born north of the Rio Grande River or south of it, says nothing about what kind of person you are. It says it's not something that you can control, and it's not something that should dictate the whole rest of your life, whether you're allowed to live in the United States or not, whether you're allowed to have freedom or not, and so on. So there are obviously various policy details that we can talk about. Ilya Shapiro touched on some of them, and I discussed them in much more detail in my book, Free to Move, and I'm happy to discuss those in the later in the debate and also in the Q&A. For now, I'll leave you with this principle that this is a power that's nowhere in the Constitution. It's highly pernicious because it amounts to a kind of discrimination similar to racial and ethnic discrimination. And at the very least, even if you assume that this power does exist, it shouldn't be elevated above every other federal government power. It should be subject to the constraints of the Bill of Rights and all the other constitutional rights that we take for granted in every other setting. Thank you.
All right, real quick, since I think I went over in my original presentation, Ilya Somin is essentially arguing that there's a constitutional right for everyone in the world to come to this country. I just don't think, you have to apply kind of a smell test to your theory of the Constitution. I just can't see that as being valid. It might have been on, he tells the history correctly, that the Alien Acts, there were several different Alien Acts at the time, were unpopular. They were chastened by the Virginia legislature as a violation of federalism and all these things. The states were relatively more powerful than the federal government at the time. They jealously guarded their power. That's a good thing. But at the end of the day, even if the Chinese Exclusion Acts were racist and the Supreme Court decision upholding them were racist, doesn't mean that there's no inherent or plenary power to regulate immigration. I think that's a better reading of the Constitution, and there's certainly simply certain things that the framers could not anticipate. The idea of people coming to this country illegally is perhaps one of them. I think Ilya Somin misspoke, or at least was making a normative claim, was making a claim about how the law should be rather than how it is, when he talked about how immigrants have the same rights, or maybe he's just saying that they should, but surely people who are not in this country have different constitutional rights than those who are in this country, which is why courts have correctly held that people who are inadmissible have no due process rights except what's provided by statute. And for policy reasons, we have statutes that provide certain things, not others. Deportable aliens do have due process rights if they're here, but they're about to be deported. Not that they're not admitted properly, but they're here properly, but then they're about to be deported. They do have due process rights because that's a serious deprivation, potential deprivation of liberty. The First Amendment, right? Different types of aliens have different types of First Amendment rights, not in terms of speaking, you still can't be censored or shut down your speech, but donating to political campaigns, for example. Second Amendment rights are differentiated as among citizens or permanent residents and others, tourists say, right? You can't just be a tourist from somewhere and say, hey, I'm asserting my Second Amendment rights to buy this gun. Fourth Amendment is treated absolutely the same for everyone. Police can't barge into your hotel room as a tourist. That's a Fourth Amendment violation. You really have to dig into the niceties of the law. When you're talking about the travel ban, religion isn't even a protected class. The president can make inclusion or entry or visa denial decisions based on religion. We've done that in the past. Preferences for priests, preferences for Russian Jews, different things like that, which is why the travel ban litigation was brought on behalf of American universities and other US citizens rather than foreigners. And so fundamentally, absolutely, we should reform our laws and let in people who seek a better life in an orderly way as a funnel, not a necessarily leaky wall. But we have to recognize at the same time that courts are there to properly balance the powers, and you can't get away with executive orders of various kinds, and that it's up to Congress rather than the states to have a patchwork quilt of unworkable immigration regulations. Thanks very much.
I too will just respond quickly so we can get to the questions. I'll just talk about two big points. One is the power of the federal government. The other is limitations based on constitutional rights. When it comes to power of the federal government, the issue is not that everyone has a specific constitutional right to enter the US. It's that this is a limitation on the scope of the power that the federal government is given. The federal government only has those powers that are listed in the Constitution in some way. This one isn't one of them. You can say, making a kind of living constitutional argument, well, there are various problems with that the founders maybe didn't anticipate, as Ilya Shapiro suggested. If so, there are various other ways those problems can be handled without using unconstitutional power. For example, if the issue is that overburdening the welfare system, you can limit, as we already do, people's eligibility for welfare. I go through a great many of these kinds of policy problems in my book, Free to Move, but they should not be a justification for the federal government using powers that it wasn't ever actually given in the Constitution, and that it only got as a result of badly reasoned and deeply racist Supreme Court decisions in the late 19th century. With respect to rights, there are some specific rights, like the Second Amendment, which Ilya mentioned, which are specifically listed as being for US citizens, or in the case of the Second Amendment, for the people. You can make an argument that maybe the people are only US citizens. There's actually a debate about what the people means. That could be a whole other separate forum. But almost all the other rights in the Constitution, they're not listed as rights limited to a particular territory or a particular group of people. They're listed as generalized limitations on government power. So the First Amendment, for example, starts out saying Congress shall make no law. It does not say it shall make no law except for immigration. And similarly with the Fourth, Fifth, and other amendments, it's the same way. And indeed, outside of the context of immigration, we readily see that, as Ilya mentioned, for instance, the Fourth Amendment applies to searches of non-citizens or immigrants' property, just as it does to American citizens. The provisions for procedural protections in criminal trials apply just as much to non-citizens, even to illegal immigrants as they do to US citizens. It's only with respect to immigration restrictions that the courts have carved out this exception. And it's true, there is a history of discrimination based on religion and speech and other characteristics. It all dates back to this late 19th century doctrine that arose during the era of Jim Crow. That doctrine is badly wrong. It should be gotten rid of. If we get rid of it, there would still be immigration restrictions. They just could not be based on characteristics that are forbidden by the Constitution, like race, ethnicity, religion, and so forth. They could still be based potentially on other things. And there could still be other policies of various kinds to address potential negative side effects of immigration. Those policies just would have to be kept within the bounds of the Constitution. There's one last thing that I would mention, that while there's certainly a history of what I would argue are unconstitutional policies here, it's not quite as extensive a history as Ilya Shapiro mentions, in that many of the preferences that he lists for people in particular religion, they're not actually preferences which say, if in order to qualify for entry, you must prove you have a particular religion. It's rather people who are being persecuted on the basis of their religion or in the basis of their ethnic group. The policy that led in my parents and other Russian Jews actually not a preference, or was not a preference, for people who actually were Russian Jews and believed in the Jewish religion. It was a preference for anybody who was classified as Jewish by the Soviet government. The Soviet government had a system of internal passports, which says you're a Jew or an ethnic Russian or a Ukrainian or an Uzbek or something else. And being classified as a Jew had nothing to do with whether you actually believed in the Jewish religion or not. Lots of people, including my parents, who are atheists, were still classified as Jews. So it was about a classification created by the Soviet government to discriminate against and persecute people, not about actual religious beliefs. So if you eliminate the doctrine which says that immigration restrictions are exempt from the constraints of constitutional rights, you could still have preferences of other kinds, including preferences for people facing certain kinds of persecution. Though in the long run, if you fully restore the original meaning of the Constitution, what we would have, instead of the current system of a presumption of exclusion, where you're presumed that you can't get in unless the federal government specifically gives you permission, there would instead be a presumption of freedom of movement, and the federal government could only keep people out in the rare cases where they could do so under one of their other powers, like powers for national defense and the like, to keep out terrorists or invading armies and the like. And obviously states would have some powers as well, as they did during the founding era, though those powers also would be constrained by individual rights. So much more can be said, and I look forward to discussing this further in the Q&A period. Thank you.
Okay, I want to thank our speakers and also thank the students for staying for the entirety of the program, which will take 15 more minutes. We're now in the question and answer period. We have microphones in the aisles, but I'm going to exercise my right to ask the first question. It is pretty clear that the two of you disagree on constitutional power to regulate immigration, whether it exists at all at the federal level. So on the one hand, Professor Shapiro suggests that Congress, and you both agree that if there's federal authority, it should be limited in the same way that all federal authority constitutionally is limited by.
I think he perhaps does not. It depends how you define. I think we differ on how that would be applied. I don't think you can write an immigration law that's racist, but we dispute whether like the travel ban actually would meet that kind of standard.
Okay, so fair enough. So my question is to Ilya Shapiro, if Congress has the authority then to correct, as you put it, sort of the immigration mess that's going on right now, what do we do if Congress can't get its act together, which has sort of been the case for a while? And then to Ilya Somin, if it's not Congress, who has the authority then to deal with what's happening at the border right now, or to build a wall, or to regulate in other ways. So I'll let you guys determine how you want to take those in
Yeah,
order.
I've been saying this a lot in lots of different policy contexts over the last, 10, 15 years, but there's no, if Congress won't act, the executive branch gets more power clause. Or if Congress won't act, the courts will rewrite policy in any given area. That's not the case for healthcare. It's not the case for education. It's not the case for immigration. And so I think it's shameful that Congress hasn't acted. It's complicated reasons for it. At this point, Congress doesn't act about pretty much anything other than a joint agreement to spend lots of money that we don't have. Yeah, we're sort of out of luck, and that's part of the tragedy of this area of policy.
So with regards to the question directed at me, I guess the question is, well, if the federal government can't fix the mess at the border, and who can? I would argue that it's a little bit like asking, well, if you're against prohibition of alcohol, which we had in the 1920s, who will fix the mess of Al Capone and the bootleggers? And of course, the answer is that Al Capone and the bootleggers were the products of prohibition. Prohibition created a vast illegal market that these unscrupulous criminals then took advantage of. And our system of prohibition of entry to most potential immigrants is what creates most of the problems at the border. We've created a vast illegal market for a good that millions of people want to have. And therefore, we have problems at the border with smugglers and criminals and so forth. Those problems would be largely gotten rid of if either these migration restrictions were abolished, or at the very least, it was made easier to enter the United States legally. Then there would be little opportunity for crime to be involved in it. And also, to the extent that there still would be problems, we would have vast new resources to address them. In my book, I talk about how if we abolished ICE and similar agencies and instead put the money into regular domestic law enforcement, we could have thousands of additional police officers. And the police certainly engage in abuse of their powers. They have problems, but there is social science evidence showing having more regular police on the streets reduces crime, because most criminals don't want to commit crimes when they see a police officer in the vicinity. So this is one of many areas where if instead of spending money trying to deter peaceful migration and deport people, we spent money on actual social problems, including in this case, crime control, we could control those problems better. And we also could eliminate an important opportunity for organized crime, which does take advantage of the situation at the border, the black market there, just like they did with alcohol prohibition, just like more and more people are recognizing that the war on drugs creates this sort of problem as well. I think something Ilya Shapiro and I agree on. If you're concerned about, say, drug gangs, the way to get rid of them is to get rid of the war on drugs. Similarly, if you're concerned about uncontrolled flows at the border or crime at the border and the like, that is mostly the product of immigration restrictions. And the best mechanism to sort out the problems is the free market, to let people move around freely. To the extent that we need government to deal with some of them, we can redirect some of the resources currently used for immigration restrictions. In addition, a freer flow of immigration would create vast new wealth, millions of additional productive people. If necessary, some of that wealth could be spent on programs to alleviate negative side effects of migration. I give many examples of how that can be done in my book, everything from alleviating possible negative effects on the wages of some native-born American workers to dealing with environmental effects and almost everything else that you can think of. There are better and more humane ways to address that than the way we try to do it now, where we actually end up making it worse.
Yeah, I almost entirely agree with that. The only kind of quibble that I'd have is when Ilya talked about eliminating ICE. I mean, whatever kinds of immigration laws you have, you need an agency to enforce them. I mean, it doesn't matter whether it's ICE or whether it's the police or whether it's the FBI or whatever. You still need to enforce what laws you have. So it's not a matter of abolishing ICE. It's a matter of reforming the laws.
Since my point is to, in fact, abolish most of the laws that ICE is tasked with enforcing, we would probably no longer need a specialized agency to enforce them. What little immigration restrictions might remain could just be enforced by ordinary law enforcement. And also from the point of view of political economy, it's better not to have an agency that has a built-in stake in promoting more immigration restrictions. We would rather assign those powers, the few residual ones that should be left, to an agency whose main focus is elsewhere, and so they wouldn't have the same kind of perverse incentives. In addition, the culture of ICE has become brutal and cruel in many different ways because this is their main mission, and that's another reason not to have a specialized agency specifically devoted to that task. We should have questions from the audience. Sure. Yeah, that's a good question. The answer is there's a great deal of variety. In my book, I talk about how, for instance, in Australia and in Canada, these powers are actually shared between national and regional governments. So the Canadian central government can grant visas to some people, but the provinces also have powers to grant visas of their own, even in some cases to people who the central government otherwise wouldn't let in. The same thing is true in Australian states. As an intermediate reform, I advocate doing something similar in the US, what scholars call place-based visas. This proposal was actually advanced by Pete Buttigieg during the Democratic primaries, and the Biden administration has put it into at least one of the immigration bills that's before Congress. It would essentially say that particular cities or states would be able to sponsor visas. Initially, the people who come into those visas, they would be limited to employers in that particular region, but after 2 or 3 or 4 years, that limitation would be abolished. A similar bill actually for state-based as opposed to region-based visas was sponsored by GOP Senator Ron Johnson back in 2017. And even though Johnson today is known as a big Trumpist in that particular area, actually, if his bill had gone through, it would have been a pretty significant step forward in terms of liberalizing immigration. So I think an intermediate policy like that would be desirable for us. And of course, under the original meaning of the Constitution, individual states did have a lot of power to keep out various types of aliens and let in others. And although today I think that would be partly constrained by the 14th Amendment, but they would still have the power to let in or keep out the non-citizens based on things like skill levels or education or the like. And while I'm not a fan of that, it would be a big improvement over the status quo. And it's an area where, as Ilya likes to say, my policy preferences differ from my constitutional preferences, from my constitutional interpretation, in that the states have more power under the original meaning, as I understand it, than I think they ideally should have.
I think even under existing law, states could have their own visas if the relevant executive branch authorities approve. Utah tried to do that at the time when Arizona, its neighbor, was trying to restrict. Utah wanted to have more like state-based green cards, effectively, or work visas at least, and the Obama administration shot them down at that point. So it's unfortunate that there is actually some room for federalism, even if you acknowledge a federal role in immigration regulation.
Should I call in people, or?
I think they should line up at the mics, right? There's 2 mics, right?
I think we can just hear you from your seat unless you'd like to go to the mic, but in the absence of a higher authority with plenary power, I'll just call on you, hopefully with the consent of Ilya Shapiro, and ask your question, please.
You can assume consent unless I withdraw it.
Okay. We have your tacit consent.
We can stay a bit longer. There's interest. There's lots of people. We can stay a bit longer.
Yeah. Why don't we take a couple more questions after this one? Just go ahead and ask your question from where you are.
So you were talking about how there should be less limitation on the immigration. Like, what should the policy be? There needs to be some policies. You can't have an infinite amount of immigrants coming in at once.
Yeah.
Our government cannot handle all of these people.
Yeah. So my answer to this, which I explicate at greater length in my book, is that there is no infinite amount of immigrants or indeed anything else. Rather, the amount that should come in, it should be the amount that is supported by the free market and private choice, which is exactly the policy that we had for the first 100 years of American history with respect to federal immigration restrictions, and the policy that we currently have with respect to domestic freedom of movement. Almost all of the arguments deployed against international migration could just as easily be deployed against letting West Virginians move to Virginia. For example, if you're poorer than us on average, they might overburden our welfare state. They have higher crime rates than we do. Some people would argue they have cultural values that we might not like, and so on. So if we can handle free migration under the free market domestically, we can handle it internationally. And in fact, we did so for the first 100 years of our history with respect to the federal government. And to the extent there are negative side effects, there are ways to address them other than by keeping people out, adjusting the welfare system, redirecting resources to crime control, many other similar steps.
If folks have classes to attend, they can go at this time, and we'll stay for a few more questions.
Sorry, I don't mean to keep you from class. Thank you for coming.
There'll be a test later on how to distinguish the Ilyas.
Yes. All test takers should read my piece on Ilya confusion, a guide to the perplexed. Which
It's a
is
little dated though.
I added one or two little updates actually.
That's fine.
Yeah, I understand. I didn't realize that there were that many, like 6 p.m.
Please go ahead.
And for those of you here, we will take a few more questions.
I wanted to ask if, with something you brought up just a little while ago about getting rid of about abolishing ICE and how giving it more to local authorities and more to domestic police, and how getting rid of ICE, well, because ICE has the incentive to have more policies put in place towards against immigrants and immigration law. I wanted to know why not giving more money to domestic police officers wouldn't put more incentives on hurting the liberties of United States citizens, including the new ones that have just come into your new, allowing having infinite.
Yeah, so that's a good question. To fully answer it, I would need to go more into the whole issue of sort of police reform and how it should happen. I've written about some of these issues. We don't have the time to go into all, and I would say a couple of things. One is, at least when you're talking about a police agency whose main job is to fight violent and property crime, they have less incentive to lobby for things where most of what they do is just restrict the rights of people seeking peacefully to have opportunity. That said, we do need to restructure the incentives of domestic police. There are a number of things that need to be done to do that. One is I would get rid of many of the domestic laws which empower police to grab people for non-violent offenses and for offenses that are victimless, like the war on drugs and others. Secondly, and the Cato Institute, Ilya's colleagues there have written a good deal about this. I would get rid of the doctrine of qualified immunity, which, to make a long story short, often exempts police from liability even when they pretty blatantly violate people's rights. And there are some other reforms that could be put in place as well. But at the same time, I'm not in favor of sort of a general defund the police effort, not because I love everything the police do or I think they don't engage in abuses, but because there is very strong evidence that from social scientists across the political spectrum that having more police on the streets is a deterrent to violent and property crime. And that crime does disproportionately victimize the poor and the disadvantaged. If you look at survey data from African Americans, something like 70 or 80% of them, on the one hand, they complain justifiably about racial profiling. On the other hand, a large majority of them actually want to see more police on the streets in their neighborhoods. So ideally, what we should have is police that are more on the ball with respect to violent and property crime, but also don't discriminate on the basis of race and are subject to accountability when they exceed their powers and violate people's rights. How to fully achieve that, that could be a form of its own. And again, the Cato Institute, Ilya's colleagues there, to actually have a number of great publications on this very topic. So thank you for that.
The point is, if you're screening for, if what you want to screen for is terrorism, public health, criminal record, those sorts of things, if you free up money from, other types of restrictions, then you can more focus on that and have lots left over for kind of either to give back to the taxpayers or to redistribute to other social programs, whatever the political priorities might be set as.
Should we go to this side?
All right. I have a question for Mr. Shapiro. So if immigration is not explicitly mentioned in the Constitution, why do you believe that immigration should be left to the federal government on the basis of it being a right of most other nations to control their borders, as opposed to the states on the basis of the 10th Amendment?
Interesting. I'm not basing it on kind of some historical, Westphalian conception of the nation state, in 1650 or something like that. I'm basing it on the idea of certain things that are implied in sovereignty, that there are certain powers that a national government has, and I do think states have some powers over immigration, certainly. But just as we divide things in a kind of a principle that Europeans or Catholics might be familiar with, subsidiarity, you push down power to the most apt level where it should be exercised. And when there are truly national issues like national defense, that's a national thing, although there are state militias or National Guard units and things like that. Similarly for immigration, when we're talking about control of the border, control of the national interests, I think it's simply inheres in what the federal government does in a way that, I don't know, the power to regulate healthcare does not.
I guess we'll do another question from this side since there isn't any line on the other side.
Yep, I guess that's as good as. So I have a question for Mr. Somin. Why do you say that it's kind of off topic, but why do you say that the federal government ought not to have authority to conduct eminent domain?
Quite simply because, for those who don't know, eminent domain is the power to condemn private property for various government projects. And the simplest answer is that it's nowhere enumerated in the Constitution. And during the first 80 or 100 years or so American history, everyone assumed that the federal government did not have that power. So when the federal government wanted property to be condemned, the typical practice in that era was they would ask the state government to do it, and then they would sort of get in cahoots with the state government to get the property. In 1876, in the Kohler case, the Supreme Court said, well, this is an inherent power of sovereignty. But they made a similar argument to the one they made in the Chinese exclusion case. For the reasons already mentioned, I don't hold with these kind of arguments. But I do recognize, I have a piece about this, that while the federal government may not have a general power of eminent domain, it's arguable that it might have a limited power of eminent domain in certain instances to implement some of its other powers, like perhaps its power to raise armies. You could say that combined with a necessary and proper clause gives it a power to condemn property when that is necessary to build a military base or something like that. You can say, well, if there's no federal eminent domain power, why do we have the takings clause? I would give a twofold answer. One is that while there's no federal eminent domain power in the states, there was at the time of the founding and today also a federal eminent domain power in federal territories. There are not yet states. And at that time, of course, that was a large part of all the territory of the US, the so-called Old Northwest, which included Illinois, Indiana, Michigan, Wisconsin, and other places like that. Also, it exists in the District of Columbia, which is envisioned in the Constitution as a special federal enclave. That said, having written an entire book about the takings clause and various articles about it, one of the striking things about it is that there was very little discussion of it and its implications when it was adopted. It was adopted almost as an afterthought because James Madison wanted it to be in there. He really liked the idea, and everybody else said, why not? Let the crazy guy have this thing. I'm exaggerating a little bit. If, on the other hand, the federal government was thought to have a broad power of eminent domain, then I think there would have been more interest in the takings clause at the time and more debate over it. So that's another piece of evidence about this. If you're interested in this, Will Bode, who's a professor at the U of Chicago Law School, has an excellent article in the Yale Law Journal back in 2013. I think it's called Rethinking the Federal Eminent Domain Power, where he goes into this evidence in more detail.
All right. Thank you very much.
So wait, so are you saying that there is a federal eminent domain power under the necessary and proper clause, something that's necessary to enforce, raising armies or,
I'm tentatively saying that there is not a general federal eminent domain power, as in a power to condemn property for any purpose the federal government might think useful, but there might be a limited federal eminent domain power, a limited power with the necessary and proper clause in situations where it's A, necessary to implement other powers, B, it's not so great as to be a great independent power. And as I suggested during the debate, I might say the same thing about immigration. For example, the power to declare war includes, I think, combined with that and a necessary and proper clause includes a power to block the entry of foreign armies or spies or the like into the United States. So when I say there is not a power to restrict immigration, I don't mean that there is no power to restrict movement of any kind ever. What I mean is there's not a general power to restrict immigration simply based on the fact that these people are not U.S. citizens. And the same thing with eminent domain.
I'd have to think about that, but I think I'm less comfortable with what that implies for the expansive nature of the necessary and proper clause than I am with a plenary power argument for immigration specifically.
Plenary power actually gives the federal government vastly more power.
Well, in general, but I'm saying a plenary power over immigration, not of anything we might want it to have.
All right, fair enough. This might be a whole other debate that we could have.
Please.
Yes, this would be a question for both. There were a lot of comparisons drawn in the debate to different countries and even America, early America when we were colonizing and coming in the early years. Do you think that there's any distinction between America being right next to Mexico with it being so crazy down there compared to like West Virginia to Virginia or like Canada to America? And if you think there is any distinction, how do you think that would affect your stance on the immigration?
So a lot depends on what you mean by a distinction. Are these cases literally identical? Obviously, there's some distinctions between them, but they're similar in the sense that all of them are situations where there's groups which are different in wealth, different in culture, different in various other ways, different with respect to the characteristics which are often cited as justifications for immigration restrictions. I mentioned before, West Virginia is substantially poorer than our state is. They have a higher crime rate. Some people argue that they have cultural values that might be inimical to those of Virginians. Similarly, we now say Canada is very different from Mexico. Obviously, it is different. It's much wealthier. During the time of the founding, there was actually extensive migration, both by Canadians going south and in some cases, Americans going north. It was an issue at the time. And for much of the first century American history, there was actually considerable migration by Canadians into the US. The founders were well aware of it. In Canada then, even today, Canada is actually on average about 20% poorer than the US. In the 18th and 19th century, 20%, I mean, on a base of per capita income. In the 18th and 19th century, that gap was larger and there was substantial Canadian immigration to the US. And the founders were aware both of that extensive migration and also they were aware of an expected extensive additional migration from Europe. It is fair to say they did not, probably at that time, did not expect extensive migration from Asia or from Latin America, though within a few years, there was actually quite a lot of refugees from Haiti because of the Haitian Revolution.
I'll add that certainly the fact of the political and humanitarian pressure from migratory flows from the South drive a lot of our immigration debates, but it's not that we have it worse. In Europe, there's a lot more. The debate is very different. Their southern borders is, the threat of Muslims and different kinds of constraints, arguably a different culture, more cultural differentiation than as between Latin America and the United States. So I mean, but that's what drives the political debate. In the last 10 years since the Great Recession, there's actually been more immigrants to the United States from Asia than from Latin America. People don't know that. They think it's the same as it always was, but there's no always. Things change over time, and including illegal immigrants, so visa overstays, things like that. Obviously, you're not going to, from China and India, you're not going to swim over and cross over illegally. You're going to come legally and stay illegally after that. So the dynamic of both legal and illegal, and now asylum claims has changed over time. It's a dynamic process.
Thank you.
Should we go to this side?
Sure.
So this question is for both, but I remember you guys briefly touched on the point system that other countries have. do both of you think we should adopt closer to that? And if so, previous presidents have talked about different areas of interest, kind of like very specific job capabilities or like families. Do you guys think we should have different preferences towards who we should be, who should get like faster admittance into having green cards and such?
So a lot of people argue, we should adopt a point system like Canada has for part of their immigration system. Australia has some degree of this as well. To my mind, this relies on a notion that the people, mostly conservatives who advocate this, reject in every other context, which is the idea that the government is a good judge of what kind of labor we should have and how it should be allocated. If government were really good at doing this, the Soviet Union and their system of allocating labor would have done really well. And Ilya's and my parents would not have needed to live there because there would have been prosperity there as opposed to here. To my mind, the best way of determining which qualifications are the ones the US economy needs is the free market. If somebody's willing to offer you a job, that's a sign you have good enough qualifications. If it turns out you don't, then the remedy for that is that you get fired from that job and you try to take another one. And I would add also that even if you think that the government is a good judge of people's qualifications at time A, that is like they look at the person and see this is the skills they have, this is the degrees they have, and they make a good judgment of this person's current skills are useful to the economy or not. That doesn't take into account the skills they can develop later. One of the advantages of moving to a freer society and a wealthier one is you can improve your skills. We readily see that domestically. When people move from West Virginia to Virginia, it's not, or from poorer states to wealthier ones, it's not always just, I want to take my existing skills, let's get a job. It's I want to move to a place where I can improve my skills in various ways. And that happens with immigrants as well. If we had something like that point system, and only let in, or most let in those people who could fit it, we would not have let in the immigrants some of them in the US, some in Europe, who developed the two major mRNA vaccines that are now our best hope to eliminate the COVID pandemic. Those people arrived as small children, or their parents arrived as unskilled laborers. Nobody at that time could foresee that these kids would eventually grow up to save millions of lives with their scientific developments. And the same thing could be said looking back through history. Immigrants and children of immigrants have won a hugely disproportionate percentage of all the Nobel Prizes won by American citizens in science. The vast majority of those people were not already qualified scientists when they moved to the US. A few were, like Albert Einstein was, but there were a great many were not. And it's here that they developed those skills and had the achievements that they were famous for. If instead we had a point to say, well, this guy isn't yet a scientist, only he has a high school degree or whatever, what you can't foresee is what that person will become, given more opportunities than they have in their native country.
I think there's room for a lot of experimentation. You can have multiple types of visas for that matter. Just a simple work permit that doesn't grant you permanent residence. It's just, while you're working, you get to stay here. You can't sponsor anyone. You can't access welfare. Then you could have kind of a green card light. So you have the right to reside here, permanent non-citizen residency, essentially. Now, debate over birthright citizenship comes up. I would not want to get rid of birthright citizenship because we don't want to create a permanent underclass where like a third generation person is still not a citizen like they have in Germany with the Turks and things like that. But anyway, and then the third level would be a normal green card with more hurdles to jump through to get it, more expensive, has greater requirements. You could also have state-based visas, as we discussed. You could have an immigration lottery, for that matter, or a tariff.
Lottery.
Well, I don't mean just a random diversity lottery, but I think I meant an auction, or a tariff, where it's if you're younger and more skilled, you don't have to pay as much. If you're older, and unskilled, you have to be rich to get in. Gary Becker, Nobel Prize winning economist, has proposed something like that. So I think it's not just do we legalize more people or not? Do we admit more or not? There's lots of room for innovation in immigration policy if there's just a way for to solve the very difficult game theoretical problem of the public choice in Congress. Yeah.
Okay, so my question was for Mr. Somin specifically. You mentioned earlier the idea of free movement. How do you prepare states for an influx of immigrants? Because ultimately, over time, the United States has become a much more centralized government. How do you give that power back to them and have it succeed?
So the main thing to advocate is, at least as a policy and moral matter, is simply to have these decisions made through people's free choices in the private sector. And the best way to prepare is to simply lift restrictions, let people move around freely, also let people build new housing in response to demand, which is something we need in the US, even entirely aside from immigration. There are places, including here in Virginia, where it's very difficult to build new housing. As a result, the poor and others are shut out of housing markets in places with opportunities. I would also drop some licensing restrictions that make it very hard for people to enter various professions. That, again, is something we need even entirely aside from immigration. If we do those things, most of the potential social problems would work themselves out. And to the extent that they won't, we would have a vast new source of wealth to tap to alleviate those problems. I discussed some ways to do that in my book. But the best thing that the state and federal governments can do in most of these situations is simply to get out of the way, to allow people to move about freely, take the jobs that they're offered, build new housing in response to demand, and so forth. By doing that, we would save a lot of public money, we would create vast new wealth, and we would get much greater freedom and opportunity for both natives and immigrants alike. We would also free natives as well as immigrants from many of the negative side effects of immigration enforcement. I mentioned already the deportation of people who are US citizens. Another thing that was worth mentioning is racial profiling, which almost uniquely, this is an area where racial profiling is actually allowed as official policy by the federal government. And that affects, obviously, not just immigrants or potential immigrants, it affects native-born Americans who are members of the same ethnic groups as immigrants, or even just look like they might be. I guess we're going to take this one last question.
So my question is for Mr. Shapiro. You mentioned earlier that the power to regulate immigration is one that comes inherently for sovereignty, like I'm presuming for either a government or a nation state. That then begs the question, what isn't a power inherent to sovereignty? Because then you could say, well, the nation state exists, so it inherently has the power to do X, and you could credibly make an argument for any power. So I would like to know how you would reconcile that with things that could potentially oppress people.
Well, I mean, that's political theory 101. We give up in a state of nature. Each individual is sovereign, but life's nasty, brutish, and short. So we give up some of our rights, some of our liberties to government in order to secure and protect our liberties. And that's consonant with the American theory of government, setting up the republic, and then we set up the Constitution, which further bifurcated that sovereign power, both horizontally in the separation of powers among the branches and vertically with federalism. And so immigration, because it deals with borders and potentially engagement with the outside world beyond those borders, that is something that is properly within the sovereign, as distinct from the general state police powers that the Constitution does not give to the federal government.
Thank you.